a name?
No, Your Honor, I was going to just have him referred. It wasn't until Sister Counsel yesterday that I found out that he had been previously been referred. So yes, I will begin the process of.
Yes, gotcha. Okay. All right, Mr. Williams. What do you?
Yes, Your Honor. I want to bring to the court that I wish they can stand full purpose honor. I do not wish an assistant in any behalf unless it's going to be Jesus Christ to go forth and stand as my own attorney. And he had made it plain unto me that he will give me what to say before the court. So therefore, I wish to go before the court, full purpose honor, my own defense. I do not wish anyone to represent me as a co-defendant attorney. So the young lady, she was incorrect. I tried to correct that when she made that statement. I do not wish her help unless she's Jesus Christ. Otherwise, I don't need her help on this matter. I am going forward before myself, on behalf of myself. And I wish the court would take and get an order to the Washington County administration to get me before the court in my body, before the court, to take and find a motion for an evidentiary hearing. That's the first thing I want to do, is get an evidentiary hearing. I've been trying to also get before the court a motion discovery. I have yet to get a copy of the motion for discovery before the court. They told me I should send that to the Attorney General. So I sent it to the prosecuting attorney here in Washington. Then they took and sent it back to me and told me it should go to the attorney. That needs to be corrected, and I will get a copy to the Attorney General for a motion for discovery, because I would like to get that motion for discovery to start, you understand, making preparation for my defense. I am going to stand pro persona before me, before the court, and I want to be in the courtroom. So if you ever want to take and hear my voice again or see my face again, get an order for me to be before the court. Thank you. The peace of God be with you and your family. Have a blessed day.
Ready to witness one of the most unbelievable moments ever caught in a courtroom. A defendant openly refuses his lawyer and declares that only Jesus Christ can represent him. Sounds like a parody, right? But no, this actually happened live, right in front of a judge. And the confidence in his voice? Absolutely
Ms. Woodson, the original competency report yesterday, so she has that.
Thing is, regarding the IME, as I listened to the defendant today and his basis for wanting to represent himself, although I don't think he needs a basis, but as I listen to it, the court has some concerns, and this court has concerns as to whether or not he is even in a position at this point to be able to make such a decision. And so I would need to have, or at least see the result of that IME prior to that determination being made as to whether or not he could even represent himself in this case, or making a decision on that, because I don't think his argument regarding that was very cogent, at least from the court standpoint. So what I will do at this point, and Woodson, you are going to begin that process.
Yes, I was going to ask if the court would consider a re-referral, but I think an IME might be a little faster. I know he's been detained for quite some time.
Okay.
Yeah.
Well, yeah. All right. So give me 60 days on the belief, and I think it would be something that you should do in terms of the IME. I'll set a competency hearing, another competency hearing for November 20th, 2022. October 20th, 60 days out? Okay, it's only October, 60 days out. I'm already in September. October 2022. Yes.
Thank you.
Now, that statement might sound dramatic, but it's also a massive legal red flag. In criminal court, defendants can choose to represent themselves, but only if the judge determines they're mentally competent to do so. Here, you can see the judge instantly questioning whether Mr. Williams truly understands what's at stake. It's a rare moment where the law and mental health collide head-on.
Derek Taylor on behalf of Ms. Lewis. Ms. Lewis, can you state your name in court?
Octavia Melissa Alexia Albertine Lewis, Brianna Alexandria Washington.
All right, what are we doing?
And good morning, Your Honor. This is the date and time set for a probable cause conference. If you could confirm, and it's because there's something different listed in the court system that I saw yesterday versus what's listed at jail as to what her actual bond amount is. I believe they tried to straighten it out last night, but I just want to confirm it, and then that may dictate.
I have a 10,000, 10%.
Okay, because in the court system, it was 1,000.
It says 1,000. I'm looking at the form right here. It says 10,000, 10%, signed by Judge Fink or Magistrate Fink on the 17th.
Yes.
So there's been some confusion as to what her jail amount or what her bail amount was.
I did have a bond hearing that was, and the bond that was 10,000, 10% got reduced to a.
When was
December.
that?
Back in December.
Okay.
On the same page.
Okay, so this, you see 817.
Yeah, the 10,000.
Just quiet, Miss Lewis.
That was the original one.
Miss Lewis.
Miss Lewis, hang on a minute, okay?
817.
Of 2022. 817. So you did. And what does that say?
You can sense the judge walking a tightrope here, trying to protect the defendant's rights while also protecting the integrity of the trial record. This isn't just about caution. It's about preventing future appeals from claiming that the court violated competency rules. Every word and decision here matters for what could happen down the line.
And so the last entry we have in JIS, which I think is just wrong in JIS, the case management system, says 1,010% for her bond. I'm looking at the court activity record signed by Magistrate Fink, and it indicates 10,000 and the 10% box is checked. So her bond right now is 10,000, 10%.
Okay. And Ms. Lewis, hang on. So in that case, we would be requesting a preliminary exam to be set as soon as possible.
All right, and we also, so that you know, back to the recorder's log of the hearings. The recorder's log indicates 10,000, 10%. So. But
I spoke with Ms. Fink at the time of my arraignment, and I let her know that there was a bond hearing, but she didn't have, she said that the original bond was 10,000, 10%, but at the bond hearing, it was lower. And I have not violated that bond. I just got kicked out of the courtroom at my last court hearing in May. It was not that I was not trying to be in court. It was that the name kept getting, the coordinator kept changing the name, and then when I tried to speak with her, she put me out the courtroom. So when I logged back in, they told me that I was too late for my court.
Okay.
I was not trying to evade court at all, sir.
Okay, so what are we doing?
So, Your Honor, in the event that Your Honor would entertain a bond motion to lower the amount, we would request that it be lowered.
I'm not entertaining anything today.
Okay. So, understood. So in that case, I would request that a preliminary exam be set as soon as possible. And hopefully next week.
This case is both frustrating and deeply human. Octavia isn't denying her pending cases. She's saying the system made a mistake. A simple name mix-up caused her to get booted from a virtual hearing, and now it looks like she missed court altogether. Her plea is heartbreaking. She asks the judge to release her on a monitoring tether instead of demanding cash bail. She's self-employed, struggling with a medical issue, and just wants a fair...
Yes.
On the administrative court, when I went to court, I stayed on there from 11 till 3:30 in the afternoon trying to get in front of Simpson. And Regina Garrett Carragher is the one that called me and told me that I would need to log in. I logged in, but my phone was dead. So it logged me back out. When I logged back in and got in there, the administrator kept ignoring my hand, logging me out. That's not fair. It wasn't me that was logging myself out. It was her. Yeah. And that is able to be seen. Even Mr. Simpson knew I waited for him to be done with one person and raised my hand like I was supposed to. I got ignored. They logged me out. That's not fair for me to be sitting in here on $10,000 on a $1,000 bond, and I was not admitted into court.
I agree. Kleeman's office can file a motion to try to get that bond changed and get you out sooner, but I cannot change it.
Okay, we'll file a motion as soon as possible, ma'am, and I'm also going to refer you over to the bail project. So just in case he does not hear the motion, we'll try to get your bail posted for you.
And I will give you personal bonds on the other two because Judge Simpson has a similar policy on the misdemeanors, but I do have a little more flexibility there. And because these are both driving while suspended files, I'm okay with a personal bond on those, even though that's not what he said. So,
another question.
Yes, ma'am.
$10,000 bond with the 10%. I'm not asking for a PR bond. Can I at least get put on tether for this bond?
I'm sorry, can you do what?
You put on tether for this bond.
I can't do that. I cannot change what Judge Simpson set for the felony.
I'm not asking you to change it. I'm asking you to, instead of using a cash bond, can I get a tether because I don't have the money so that I can still be out, but they can know exactly where I'm at.
Yeah, that's still a change that I don't have authority to. But I am giving you a PR on the misdemeanors, and the court date for that will be September 6th on both of them. All right, anything else for today?
No, Your Honor, thank you.
Okay, all right.
What's my bond?
I can't, your bond, so it's the 1,000.
That's
10%. Yeah, it's $1,000. And Ms. Kleeman is going to refer you to the bail project to try to get some help in getting that posted.
Now let me get a clear understanding. I need $1,000 cash or $100 cash.
No, you need $10,000 or $1,000. I'm allowing you to post 10%. Judge Simpson set it at 10,000, 10%. So 10% is 1,000. I'm giving you a PR on those misdemeanors, but you've missed court several times on that. So you got